Right now, social media feeds are full of dramatic claims. Some people say it's a rumor, others insist it's fake news. 39-country deportation wave. Mass removals. ICE is coming for ESTA travelers. I'm not here to validate rumors or spread panic. I'm here to talk about one thing only: the law. And today I'm going to walk you, carefully and calmly, through what the Immigration and Nationality Act, specifically Section 217, actually says, what it means in practice, and why it matters if you entered the U.S. under the Visa Waiver Program. Because there's a critical detail almost nobody on social media is explaining. If you or a family member came to the United States using the Visa Waiver Program, ESTA, and stayed past the 90-day limit, your legal situation is not the same as a typical visa overstay. In many ways, it is more fragile. And it's important to understand why before enforcement agencies know your circumstances better than you do. What I'm about to explain isn't speculation. It's based on the statute, and it's already being applied in 2026. My name is Timothy. I'm an immigration rights strategist and the founder of US Updates Hub. For years, I've studied the specific legal mechanisms that put non-citizens at risk, not to frighten people, but to help them navigate a complex system with clear eyes. In this video, I'm going to do 4 things. First, explain what the Visa Waiver Program is from a legal perspective. Second, show you one important right you agreed to give up the moment you entered on ESTA, even if you didn't realize it. Third, outline 2 common situations that can result in a Visa Waiver Program overstay being removed from the US extremely quickly. Fourth, share practical legal shields and sample phrases you can use if immigration enforcement ever contacts you. If someone you care about entered on ESTA and is still in the US, don't skip pieces of this. Pass it to them while you watch. Understanding this distinction can make a real difference. Let's go back to the beginning, when the key decision was made, often without anyone fully realizing its impact. You arrived at a US airport, maybe JFK, LAX, or Chicago O'Hare. You held a passport from a Visa Waiver Program country: Germany, France, Japan, South Korea, the UK, Australia, and others. You completed the ESTA form online, paid the fee, and received approval. Upon arrival, you handed your passport to the Customs and Border Protection officer. They processed you, stamped your document, and you walked through. No visa interview, up to 90 days of permitted stay. It felt simple and efficient. What's easy to miss is that, as part of using ESTA, you consented to specific conditions laid out in INA Section 217. One of those conditions involves your rights if the government later decides to remove you from the United States. The law states that by using the Visa Waiver Program, the arriving person waives any right to contest removal, aside from seeking asylum. In other words, under Section 217, if you enter on ESTA and then overstay or violate your conditions, you do not have the same default access to an immigration court hearing as most other categories. Here's what that means in practice. If someone enters on a standard B1, B2 tourist visa, overstays, and is later placed in removal proceedings, they generally have the right to a hearing before an immigration judge, the ability to have an attorney represent them, the opportunity to request continuances, and present evidence. That process can take years. This is what many people think of when they imagine fighting an immigration case. But if you entered using the Visa Waiver Program and then remained beyond your authorized stay, you're in a different category. In those cases, immigration authorities can use an administrative removal process. That process is handled internally by enforcement officials, not by an immigration judge. Key differences: no automatic right to a full court hearing, no requirement that ICE obtain an order from an immigration judge. Decisions can move much faster, sometimes resulting in removal within a very short period after apprehension. This isn't a future proposal. It's how the law is structured today. With that foundation, let's talk about 2 common misunderstandings that can cause real harm. The first is what I'd call the due process assumption. Someone is picked up by ICE. They or their family reach out to acquaintances, maybe a friend knows a lawyer, and they're told, "Don't worry, you'll get a court date. These things take years. You're going to have time." That advice might be accurate for certain visa holders, but not necessarily for someone who entered on ESTA and overstayed. If you came in under the Visa Waiver Program, your options can be much more limited. Waiting for a hearing that the law doesn't guarantee can be a costly misunderstanding. The second is the emergency marriage fix. This scenario plays out a lot. A person who overstayed ESTA begins a relationship, hasn't yet pursued any formal immigration pathway, and then an enforcement action occurs. In the panic, someone suggests, if you marry a US citizen right now and file a petition, they can't deport you. That idea sounds comforting, but it can be dangerously incomplete. A family-based petition, Form I-130, is a request to recognize a qualifying relationship. It does not, by itself, automatically stop an administrative removal that is already in progress under the visa waiver rules. If ICE has already started administrative procedures, getting married and filing a petition at the last minute may not prevent removal. The U.S. citizen spouse could end up trying to adjust the status of a partner who is no longer in the country. So if you entered on ESTA and overstayed, your position is structurally different from a typical visa overstay. Your options can be narrower and timing becomes critical. Now let's look at the potential protective paths that do exist. The first significant exception built into Section 217 relates to asylum. The statute provides that although visa waiver program entrants generally waive the right to contest removal, they still retain the right to seek asylum. In practical terms, if you entered under ESTA, you overstayed, and enforcement takes you into custody, and if you have a real, genuine fear of persecution in your home country based on factors such as race, religion, nationality, political opinion, or membership in a particular social group, you have the right to state that fear and request protection. That triggers an asylum screening process. You should be referred to an asylum officer for a credible fear interview. If you meet the threshold, your case proceeds under the asylum framework. It's very important to stress, asylum is a serious legal claim, not a delay tactic. It should only be asserted if your fear is real and based on grounds that meet legal criteria. Misusing asylum can create separate problems, but if your situation truly fits, that exception is a critical safety valve under the law. The second potential strategy concerns timing for those who are immediate relatives of U.S. citizens, spouses, certain parents, and adult children. There is case law and policy guidance indicating that USCIS, not ICE, may be able to adjudicate an adjustment of status, Form I-485, for certain visa waiver program overstays who are immediate relatives, if the adjustment application is filed before enforcement action and before any removal order is executed. In practical terms, that means if you entered on ESTA, you overstayed, you are married to a U.S. citizen, or qualify as another type of immediate relative. And you file a well-prepared I-485 early before ICE enforcement begins, then USCIS may still consider your application and in some circumstances can approve it despite the overstay, as long as no final removal order has been carried out. This is a nuanced area of law and policy. It's not a guarantee. It absolutely requires the guidance of a qualified immigration attorney because you must be otherwise eligible. Your record must be carefully reviewed. Timing is critical, but the main point is advanced planning and early filing can, in some cases, shift your case from an enforcement track to a benefits track. Waiting until there is a knock at the door often removes that option. Here's a simple, practical action plan to consider. First, confirm exactly how you entered the United States. Check your passport stamps and your I-94 history on the official CBP website. Did your record show ESTA, VWP, or did you use a traditional visa category like B1, B2? That one data point dramatically affects your rights and options. Second, if you determine that you entered under the visa waiver program and are now past your authorized 90-day stay, it is advisable to speak with an experienced immigration lawyer promptly, not next year, soon, because certain strategies depend on acting before enforcement initiates, not after. Third, if law enforcement or immigration officers come to your door, you are generally not required to open the door unless they present a warrant signed by a judge, a judicial warrant, not just an administrative form. You can speak through the closed door and ask, "Do you have a warrant signed by a judge?" If you are detained outside your home, you have the right to remain silent and the right to consult an attorney. You can say, "I am choosing to remain silent and I want to speak with a lawyer." Then avoid discussing your entry, your prior travel, or your status until you've had legal advice. If you genuinely fear harm or persecution in your home country and removal is being discussed, you can clearly state, "I am afraid to return and I want to request protection." That may trigger the asylum screening process mentioned earlier. Fourth, understand the longer-term consequences. A formal removal order, even through an administrative process, can trigger significant bars on re-entry to the United States, often 10 years or more. It can also permanently disqualify you from using the visa waiver program again. Knowing that helps explain why it's so important to get accurate information and act early instead of hoping things will work out on their own. One final point. Knowing your rights and understanding the law does not make you dishonest or uncooperative. It makes you prepared. The officers who enforce immigration law operate under detailed regulations and training. The more clearly you understand your own situation and options, the better able you are to make informed decisions in a stressful environment. If you have relatives or friends who entered on ESTA and may not realize how their situation differs from other visitors, sharing accurate legal information with them could make a major difference. The legal framework in INA Section 217 is real and already in force. At the same time, there are narrow but important exceptions and strategies that can sometimes help people in difficult situations, especially if they act early and with proper legal guidance. Stay informed, stay organized. And if this applies to you or someone close to you, consider speaking directly with a licensed immigration professional who can evaluate your specific facts.